Hello and good afternoon, everyone. My name is Halley Auger. I'm an employment lawyer at Samfiru, Tumarkin, practicing out of Alberta and, in fact, in our Calgary office. Today is our final live stream before the holiday break, so I've got my holiday sweater on. And while the questions are rolling in, I'm going to talk a little bit about the difference between a holiday bonus and an end of year bonus, because they really are different, although the timing of when they get paid might be the same. A end of year bonus is usually a bonus that's built into your compensation model at your company. It's usually based on individual performance, company performance, or business unit performance. Usually it's a substantial part of your compensation, and it's maybe a little discretionary because it depends on company performance or your performance, but generally it's paid year after year, and it's mentioned in your employment contract. So those are year-end bonuses that are just happen to be paid at the end of the year, but are a part of your compensation that you are entitled to. So if at the end of the year, for some reason or another, your employer is saying you're not getting your bonus and you've habitually received your bonus, please contact us. That certainly is your employer changing, perhaps significantly, a part of your term of your employment. A holiday bonus is a little bit different. A holiday bonus is, either a gift card put into a holiday card or a Christmas card from your employer. Usually the amounts aren't big, and usually you get it just by virtue of being an employee of the company. It really is seen as a gift. And so some employers give them routinely, but in terms of the requirement to, it really is gratuitous. And so if your employer isn't paying your holiday bonus this year, it's truly unfortunate. But unless it's built into your employment contract that you get a holiday bonus, which is more like a Christmas gift, there's not a lot you can do. If you're not sure, if your employer's not paying one this year and you're not sure if you get a year-end bonus or a holiday bonus, and if it is a significant change to your employment relationship, please don't hesitate to reach out. You can find us at employmentlawyer.ca. All right, we've got some questions rolling in. Now, we don't expect a ton today. Hopefully everyone's wrapping up for the year and getting started. I cross my fingers when I say that. I hope that employers aren't letting people go or being Grinches over the Christmas season. We don't like to see terminations over Christmas. And part of the reason for that is because it's known it's the slowest hiring season of the year. And as soon as you're terminated, you are going to be looking for a new job. And if there's nothing available, you're going to be out of work for longer. So if you are being terminated over the holidays, sometimes you may be entitled to a little bit more severance. It's called the Christmas bump. All right, question on YouTube from Cherry. My manager has decided to hold a staff vote to determine who will be fired. This seems unfair and like bullying. Is this even legal? I've never heard of this. I mean, this isn't Survivor. This isn't a reality TV show. I think it's outrageous. And yes, I would absolutely agree that that's bullying and harassment. Bullying, we actually have legislation that prevents bullying and harassment in the workplace in Alberta. It's under Occupational Health and Safety Act. So this would absolutely be bullying. A manager cannot deflect managerial duties onto the staff. So certainly, I've got a big issue with it. I think it's a big issue for any of the employees and not just the one who's on the chopping block, because that essentially means that your employer is asking you to participate in some bullying and harassment. So Cherry, if this has your spidey sense going, you're absolutely right. It's inappropriate, it's improper, and feel free to reach out if you feel that your employer isn't maintaining a safe workplace from bullying and harassment. So please go to employmentlawyer.ca and reach out to our intake team. Question on Reddit from Harry. My company has said that they can ping our cell phones to find out where we are when taking a sick day. How legal is this? If your company doesn't own your phone, I can't read the rest of the question. These are weird questions today. I've also never heard of an employer doing that. Now, certainly your employer has a right to control its workforce. And so, I mean, I can't imagine they would have a situation where people were overusing sick time. That tends to sort of be an old wives' tale. We don't really see it in workplaces. So if there's a substantiated issue that your employer has talked to the employees about, saying, so many of you are taking sick days, and then we see you posting on Instagram that you're on the ski hill, and now we need to crack down on this. Maybe, but even then it's strange. I would think that that's sort of interfering with someone's privacy. Now, obviously, this isn't an issue if you are sick at home, but to be able to ping your cell phone, I see that as an overreach. I see it as an invasion of privacy. And certainly if they're imposing that on you and it wasn't a term of your employment agreement that says your employer is allowed to sort of track you and know where you are at any given time, I would think that that's also an issue about your employer trying to change your employment relationship. I think it also shows a deep mistrust. And trust is a part of the employer-employee relationship. We do have to sort of trust each other. So, Harry, I think it's bizarre. I really hope that's a hypothetical and that it's not really an employer in Alberta doing that. I would have a problem with my employer wanted to do that to me as well. So certainly reach out if you want some further information on this. Go to employmentlawyer.ca. Question on Facebook from Binga. I was dismissed during the probationary period. My manager called me and said, "We are terminating your employment based on your performance." Said all the best and left the call. She never mentioned or even discussed my performance during this period. Should I have been given warnings or criticism leading up to this? Binga, that's a great question. We actually get this question all the time. Probationary periods, first of all, in Alberta, the employer has 90 days to test you as an employee. They can terminate you, at any time before or after the 90 days. The issue is really whether you're entitled to a mandatory termination pay under the Employment Standards Code. If somebody is terminated during the 90-day probationary period, they may not get their 1 week's pay as if they were 90 days to 2 years. However, that's just a mandatory minimum payment. You could still be entitled to common law severance. It really turns on the wording in your employment agreement. Binga also raises a great point about whether she was really given a fair shot. If her employer had a problem with her performance, why is she hearing about it for the first time at her termination meeting? A probationary period is meant to sort of test the waters on an employee. And then if they don't work out, give them, you have the ability to let them go without paying termination pay. However, there is case law. In fact, there's case law in multiple provinces that says you really need to give somebody the opportunity to show who they are. If you're not giving them that opportunity and you're not providing them with feedback or coaching, it certainly can be an unfair dismissal, in which case you can be entitled to severance. All right, question on YouTube from Strange Salt. I'm currently working in a repair shop and I'm being treated poorly. There's a whole bunch of problems with this workplace, one of the main ones being the safety of the place. One example would be people without a forklift license having to operate the forklift, including myself. They hire vulnerable people who need to be employed. What can I do about this? Strange Salt, I'm really disappointed to hear that your employer is allowing serious safety issues to go on, particularly if you have vulnerable people in the workplace. This falls squarely under occupational health and safety legislation. What that means is in Alberta, there is legislation that requires employers to have a safe workplace and to take all reasonable steps to ensure that employees get to work in a safe fashion. If your employer is not creating a safe workplace, you are entitled to refuse work until the safety issue is addressed. The people who are being asked to operate the forklift license without a license can refuse that work. If the employer retaliates against you in any way, whether it's cutting your pay, taking you off shifts, or terminating you, that's retaliatory for raising a safety issue, and that's illegal. Occupational health and safety legislation is also designed to prevent retaliation for refusing to work in unsafe conditions. Now, I'm also concerned because Strange Salt is saying that he's being treated poorly. I don't know the particulars of that, but being treated poorly can be a harassment, bullying in the workplace. It also can be discriminatory if you're being singled out and treated poorly because you're a member of a protected class, a certain age, race, religion, gender, sexual orientation, etc. And so if you're being singled out and treated poorly because you're a member of this protected ground, that's discrimination. If you're just being bullied, that's a health and safety issue under occupational health and safety legislation. So for Strange Salt, you can actually reach out to occupational health and safety directly to report safety issues. You actually can even make anonymous complaints if you are worried about retaliation. If you are looking for further assistance on this, we're happy to help you as well. Please reach out to employmentlawyer.ca. Okay. Lauren Bailey's asking, how do we ask questions? Lauren, you can leave a comment just like you did. I just got that comment, so I would get your question as well. Or you can send it private via direct message and we'll post it anonymously. Okay, Renee F. Is it true that for a new employment contract to be enforceable or valid, consideration must be given? Some benefit for signing a new contract since you're already working on a current contract. Yes, it sounds like Renee's done first-year law school. So the first thing we learn in law school in contracts class is that in order for a contract to be binding, there needs to be an offer. So your employer offers you employment. You need to accept it, saying, yes, I accept these terms. And there needs to be something that exchanges hands. Renee has pointed it out, called consideration. All that means is there's an exchange of something. It's called the peppercorn rule. And that means that at least something as valuable as a single peppercorn must be exchanged. How employment law is developed is that continued employment is not a peppercorn. If you're not getting anything new, a pay raise, a bonus, even a signing bonus, more vacation, if you're not getting something in exchange for signing a new contract, there may be void for lack of consideration. Now, what I want you to look for, and the reason why employers do new employment contracts during the course of employment, is because they're probably taking away something from you that you didn't know you had. And that most specifically is entitlements to common law severance upon termination. So employment lawyers like me have been fighting against termination clauses that says if an employer lets you go without cause, they only have to pay you a very, very small amount. We've been fighting on the wording of those contracts for decades. And what it's done is employers draft contracts that help them. They are trying to limit your notice on termination to only the bare minimum payment that must be paid to you and nothing more. So even though you have potentially what looks like a termination clause in your initial employment contract, if it's old, I mean, even 5, 7, 10 years old, there's a strong chance it's not enforceable language. And so if your employer is trying to give you a new contract, look very, very carefully. If the wording of your termination clause is not identical, even a few words missing or moved around, I suspect that they've hired legal counsel and they are making that clause enforceable. So certainly reach out to us if you'd like us to review the new contract. If your employer is not giving you anything new in exchange for it, it may be void for lack of consideration, and it wouldn't be held to be enforceable if your employer then terminates you and tries to limit you to the mandatory minimum payment as set out in the new contract. Renee, if you're not a law student, you very well could be. You've got a legal mind. Okay, question on YouTube from Paige. I was placed on a temporary layoff for 13 weeks. Today, I received an email that I have 2 options: take a demotion and return to work in a different department, or extend my layoff until February. Are they allowed to do this? So Paige, lots to unpack there, because whether your employer was even allowed to initially place you on that layoff is a question for your contract. There is no common law right to lay off an employee. That means that if an employer wants to have an ability to temporarily lay off an employee, they have to put that in an employment contract. As an employee, if your contract doesn't allow a temporary layoff, when you get your temporary layoff notice, you have a few options. You can accept the temporary layoff, or you can refuse the temporary layoff, and your employer can immediately recall you back to work, or you can treat yourself as being constructively dismissed. So Paige sounds like she's gone beyond that. Perhaps she's at the 13-week mark. And that is that she's being told that she has 2 options: to take a demotion and return to work in a different department, or to extend her layoff. The employment standards legislation allows a layoff for up to 90 days in a 120-day period. And it sounds like they're right at that period of time. An employer can extend that only with the consent of the employee and by continuing to pay benefits for the employee. So they're allowed to do it if you agree to it. If you don't agree to it, then no, they're not allowed to do it. Whether they're allowed to offer you a demotion, that could be a constructive dismissal. So normally we allow our employers to make changes to our employment relationship when they want to increase it. My employer wants to pay me more money, I'm fine with that change. If my employer wants to promote me, I'm fine with that change. If they want to give me more benefits, I'm fine with that. More vacation, I'm fine with that. But if your employer wants to make changes that are negative or adverse, a demotion, a pay cut, changing your work location to now you've got to drive 45 minutes away, you have the choice. You can accept that change, or you can reject the change. You can say that change is too substantial and I don't accept it. The ball is then in the employer's court, and they can say, okay, fine, we'll leave you in the job with the same pay at the same location. Or they can say, no, we can't do it. We're demoting you and you're moving from a manager to a laborer. And now you have to report to the people who used to report to you. That's a constructive dismissal. Contact us immediately and we can help you. Now, what I also want to do, and I'm sorry if I'm not getting to your next questions, but I think Paige is onto something that's just so important, is contact us now. Don't contact us later. Constructive dismissals are a challenge. And what we don't want is somebody who's being seen as resigning or abandoning their position. Contact a lawyer early. If your employer has put you on a temporary layoff, contact us. If your employer is telling you, hey, next week or next month or next year, we're making some substantial changes to your employment, contact us. Don't wait until after the change. Part of the reason for that is, as lawyers, I'm very, very good, but I have a law degree and not a magic wand. So I can't undo history. I can help you, guide you in the future, but I can't undo things backwards. And if you've done something, I may not be able to undo it. The other thing is there's a principle at law called acquiescence. What that really means is silence is acceptance. And so we need to make sure that you're not, by virtue of your silence, not raising an issue with the change or the layoff or the demotion. You could be seen as accepting the change. So contact us soon, contact us early. We've got employmentlawyer.ca. You can email us at help@employmentlawyer.ca. You can also call us at 1-855-821-5900. Okay, question on YouTube from Nompak. Am I protected by the ESA if I have no contract? Yes, you're protected not only by the ESA, which is the Employment Standards Act, although we call it the Employment Standards Code in Alberta. You are protected, and in fact, you're protected by common law. So in Canada, we've got multiple ways of making laws. We've got legislation, so statutes like the Employment Standards Act or the Employment Standards Code of Alberta. And we also have laws that are made by judges. So they hear court cases, they make a ruling, and now that ruling is a law. So that's called common law. And if you don't have a contract, you are protected by the Employment Standards Code, which sets out some mandatory minimums, but you're also entitled to greater rights, which is that common law. So we love when employees don't have contracts. And the reason is, and I've said it earlier, is the contract is drafted by the employer because it helps the employer. So not having a contract doesn't mean you don't have rights. It actually means you have the most enhanced rights of any employees because you're not limited by an employment contract. Okay, a question on YouTube from Hobby Lover. How much time do I have to do a constructive dismissal after pay is reduced? So you're going to hate this answer, and even as a lawyer, I hate this answer because the answer is a reasonable period of time. And so that can mean a lot of different things to a lot of different people. Certainly, it's factually specific. I wouldn't go longer than a week or two. I wouldn't go longer than a pay cycle. What you can't do is wait a year or two and then say, I don't accept this change, because it's clear that you did, because you didn't do anything for a year or two. So really, it comes down to what's reasonable in the circumstances. It depends how much notice in advance you got of the pay reduction, because if they gave you 6 months notice and you didn't do anything in that 6 months, and then the change comes into effect, and then you wait 6 months, certainly that may not be seen as reasonable. I've seen some case law in Alberta that has suggested it was about 2 weeks. Now, that's certainly not a rule of thumb. That doesn't mean if it's been a month or 6 weeks that you still can't assert constructive dismissal. You may be able to, again, contact us early. question on Facebook. I am part of a management team of 3 and am constantly left out of decision-making and meetings. I have a direct manager I report to who only gives me negative feedback and only in email, never in person. I feel like this is some sort of harassment. I went to HR and they suggested to talk to the manager. And I'm not sure if this is part of the same question, but I work 2 jobs, one full-time and one a contract position. I'm very stressed. I'm not sure if that's the part 1 and part 2, but okay, we're just going to answer part 1. The question is part of a management team being cut out of decision-making and meetings, only getting negative feedback. Is it harassment? You did take the right step of going to HR, and they suggested to talk to the manager. Obviously, talking to the person is a great first step. It could be harassment, particularly if you're being targeted. Being excluded from meetings, decision-making meetings, can be seen as taking away duties or undermining your authority. And so, that could be a workplace issue, particularly if the person who's cutting you out, you report to. Talking to HR is a great first step. We don't want you to sort of, take too drastic of an action, but raising the flag. Suggesting talking to the manager, you can ask for HR to be involved in that conversation as well. You don't have to do it on your own. You can ask for sort of a mediated conversation. Okay, now the next question. I'm not sure if this is part 2, but if it is, I'm just going to answer it separately. I work 2 jobs, one full-time and one a contract position. I'm very stressed. I feel I need to stress leave for my full-time job, but I want to continue working my contract position. Is that legal? Would I get in any trouble? It depends if your stress leave is being paid, and if it's being paid, whether it's being paid through an insurance policy. So stress leave is a medical leave. Medical leave can be paid for through EI if you don't have short-term disability in place. And if you do have short-term disability in place, then the terms of your short-term disability policy apply to whether you're able to work or not. Normally, I think if somebody wants sort of the quick answer is a stress leave is a medical accommodation. It's no different than you having a carpal tunnel, where you can do some work, but not highly repetitive work with your arm. And so just because somebody has carpal tunnel doesn't mean they can't do any work. It just means that they can work with limitations. And so certainly, to say that you can't do your contract position, well, you can. Your medical condition may prevent you from doing certain work, but not others. But certainly that's going to be a question for whoever is paying for your benefits during your stress leave. If it's nobody, if you're taking an unpaid stress leave, then I don't see it being an issue. If you are going to be accessing EI sickness benefits or a short-term disability policy, you'd have to look at the policy or direct the question to EI. Okay, well, I think that's all the questions we have for today. I want to say thanks to everyone for coming to our last session for 2024. We'll be back in 2025 with more questions, more lawyers to answer your questions as well. All right, take care.